Please be seated. Proceedings are resumed. Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? I recognize the Honorable Minister responsible for education.
Madam Speaker, thank you. I rise to give support to the SPS document which the government has just tabled. And also, Madam Speaker, just to give some brief remarks to expand upon an area which was touched on briefly by the Minister of Finance and also by the Premier in their contributions, and that is to do with the area of the government's focus on commitment to improving the employment prospects for the country. Madam Speaker, as the Minister of Finance stated in his address, and as is reflected in the SPS document, the government continues to support the training, the development, and the employment access through the work of the National Workforce Development Agency and through the emphasis that the agency is putting on helping to assist Caymanians upskill as well as access employment opportunities in the environment. But Madam Speaker, the SPS document also reflects a number of other areas because this government recognizes that the approach to tackling the issue of employment and that of unemployment, Madam Speaker, has to be a whole government approach. In the SPS, you'll notice, Madam Speaker, that the government speaks to the need to have a stronger collaborative working relationship between the various agencies in the government, including that of the Immigration Department and other government agencies, Madam Speaker, the Department of Children and Family Services and otherwise. Because, Madam Speaker, the way our legislative framework is structured, and it has been this way for many, many years, our primary piece of legislation dealing with employment policy, Madam Speaker, is that of the now immigration law, which is the latest iteration as it was from the original Caymanian protection law. So, Madam Speaker, the government recognizes, and as the SPS reflects, there has to be greater cooperation, greater collaboration, greater emphasis on placing and developing and facilitating a greater transparency in the job opportunities that exist in the market, and therefore creating and facilitating a greater and a more transparent work permit process. Madam Speaker, the government has worked very hard over the past year to ensure that the Immigration Department and its boards are aware of which Caymanians who have taken the opportunity to register with the National Workforce Development Agency to show that they are available and ready for work. The Immigration Department is now aware of this because of the collaboration that has happened over the past year. Madam Speaker, the government is committed to continuing to encourage further collaboration between the departments by having and hopefully promoting further transparency with respect to which jobs are actually coming to market, that being the case with having a more transparent approach to which companies have jobs that are available that are currently held by work permit holders that in essence will be coming to market, so to speak, upon the expiration of such applications, And hopefully, Madam Speaker, that information is able to be accessed by the public in a more transparent manner. Because, Madam Speaker, the system that we have now, we recognize we do need to do more with respect to making sure that that information is readily accessible, and that waiting to see which ads come out in the relevant papers for 2 weeks in a row is not what we need to ensure that those employment opportunities are actually made readily available and accessible. And so, Madam Speaker, the emphasis in the coming year will be to look at how we can improve this information sharing from the immigration and its databases to that of the NWDA to be able to give a better picture, Madam Speaker. The government must continue to commit to making this information readily accessible on a rolling basis. Which jobs are actually available, which jobs that could be held by suitably qualified persons, suitably qualified Caymanians, which jobs are actually currently coming online as a result of the expiration of work permits or otherwise. And so by having a more transparent database at the immigration end and figuring out how that actually should work is going to be an emphasis that the ministry will be continuing to promote. And we look forward to working with the relevant ministries and departments as it relates to the immigration boards and the immigration database regarding work permit process. Madam Speaker, the government must also recognize, as I've said, because of the primary nature of the immigration law and its role with respect to facilitating employment in the country, that there are certain inadequacies that still exist, and that we therefore need to make sure that we look at strengthening the legislative regime as it relates to the job advertisements and what is required currently under the immigration law as it relates to the accessing information about which jobs are available. Because, Madam Speaker, it's no longer acceptable to have a situation where people can find out about jobs overseas long before they know which jobs are available locally. And so these are the kinds of things that the government will need to look very critically at and determining how we move forward to addressing these concerns. Madam Speaker, the issue of job and job creation that was touched on, that is discussed in the SPS, and I just again want to draw the connection between the whole government approach that is being taken to employment. As discussed on page 18 of the SPS as an example, the development and the construction projects, which the Minister of Finance talked about as being a key vehicle for job creation as expected in the next coming year. Madam Speaker, the government must continue to do as we have done this year and moving forward. We must make sure that mechanisms are built into any incentive packages, any concession packages, any discussions, any conversations, any development projects that we want to ensure that real mechanisms, real opportunities to provide real jobs for Caymanians, that those discussions are had at the beginning, from the get-go, and not just discussions being had, but actual action taken to ensure that suitably qualified Caymanians are given the real opportunities, and that these companies and these developments are incentivized to ensure that they look to attract and hire Caymanians as a part of this project, because there is no point in talking about job creation if our people if we're not actually able to access those particular jobs. So these are some of the ways that the government is looking to ensure that when we talk about job creation, that the actual qualified Caymanians who can access these opportunities are given the real abilities to do so, and that these developments and developers are actually given the impetus to actually take action to find qualified Caymanians. Madam Speaker, another way that the government is considering, and I'm happy to say that the Ministry of Education, Employment and Gender Affairs have already taken steps to do such, but I know it's a consideration that is being had by the government as a whole. But another opportunity to ensure that employment continues to stay front and center as a focus for this government as a whole, because of course, Madam Speaker, every single one of us in here recognizes the great importance and campaign on the need to ensure that we continue to provide opportunities for real employment for our people. One of those ways is to look at the Cayman Islands government procurement process as a whole and how we can find ways to incentivize people that the government contracts with, people that the government engages in tendering processes for various projects regarding various ministries, looking at ways to include incentives or looking at ways to recognize and give credence to those companies that can demonstrate that they have actually employed and that they are actually seeking to employ Caymanians in the process. And so what the ministry has done is to adopt a policy that all projects, all contracts that are out for tender, that there is an opportunity for companies that can demonstrate having Caymanian qualified employees on board to deliver the service to the ministry and the various departments, that those entities would be given recognition for doing so through the whatever the contract, the construct of the contract is. And so by taking a whole government approach to this, and this is something that I actually would encourage the entire government to adopt, so the Deputy Governor's Office is something for them to consider, but as I said, individual ministries I know are contemplating doing a similar move. The Ministry of Education, Employment and Gender Affairs has taken this step, and we look forward to having more of a directed and targeted approach taken by the entire government to show and demonstrate that we not only recognize the importance of creating real opportunities, but we can find ways to incentivize that in an appropriate manner, which still ensures that the job gets done by the best and most appropriate person, but obviously making sure that the real opportunities do trickle down to the population, the qualified Caymanian population that's able to do the jobs as well. And so, Madam Speaker, with those few words, I would just say thank you to the Minister of Finance for tabling this, and I look forward to continuing to work with this government to continue to find solutions and to take this country forward in the way that we are embarking on now and into the future as we need to go. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the mover to exercise his right of reply.
Thank you, Madam Speaker. Madam Speaker, I am delighted that the strategic policy statement and the presentation made by the Honorable Minister of Finance and subsequently the discussion of the policy direction of the government by myself appears to have been met with general agreement. And I thank all members on the opposition benches for their tacit support of the government's policies and fiscal plans. I just wish to clarify one matter that has arisen since the delivery and my announcement that the civil service would be receiving a 4% cost of living adjustment with effect from the 1st of July 2015. There is apparently some confusion around whether or not it is 4% or whether there is some other figure. I'm not going to mention any of the other figures that have been put to me because that's just going to add to the confusion. I just want to assure the civil service and everyone else that it is 4% cost of living adjustment with effect from the 1st of July 2015. And so, Madam Speaker, with those few words, I again thank all honorable members of the House for their support, spoken and tacit, of the government's strategic policy statement, which will set out the broad parameters for the development of the 2015-2016 budget of the Cayman Islands government. Thank you, Madam Speaker.
I'm just waiting for a copy of the motion so I can put the question. The question is, be it now therefore resolved that the Legislative Assembly approves the policy priorities, aggregate financial targets and financial allocations set out in the 2015-16 Strategic Policy Statement as the indicative parameters on which the 2015-16 budget is to be formulated. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, government motion number 3, 2014-2015 is hereby passed.
Government motion number 4 of 2014-15, the Development and Planning Law 2011 2011 revision, the Development and Planning Amendment Regulations 2014, to be moved by the Honourable Minister of Planning, Lands, Agriculture, Housing and Infrastructure.
Honourable Minister of Planning.
Thank you, Madam Speaker. I beg to move government motion number 4 of 2014-15 entitled The Development and Planning Law 2011 Revision, the Development and Planning Amendment Regulations 2014.
The motion has been duly moved. Does the Honourable Minister wish to speak to it?
Yes, Madam Speaker. Madam Speaker, let me first of all read the motion so that it is clear to everyone. The motion reads as follows. Whereas Section 42(1) of the Development and Planning Law 2011 revision provides that the Cabinet may make regulations, and whereas Section 42(3) of the said law provides that no regulations shall be made pursuant to the said law unless a draft thereof has been laid before the Legislative Assembly and a resolution approving the draft has been passed by the Legislative Assembly. And whereas the draft Development and Planning Amendment Regulations 2014 were laid on the table during a sitting of the Legislative Assembly, be it therefore resolved that the draft Development and Planning Amendment Regulations 2014 be approved by the Legislative Assembly in accordance with the provisions of Section 42(3) of the Development and Planning Law 2011 revision. Madam Speaker, as members will recall, at the last meeting of the Legislative Assembly, government gave its commitment to present the development and planning amendment regulations for debate and passage through this House. The purpose of these amendments, Madam Speaker, is to assist both the public and the Planning Department with operational efficiency. For example, now the public can look to the regulations for all the rules and the criteria by which the development in the Cayman Islands are regulated. The main changes to the regulations, Madam Speaker, I will probably not go through every single one because some of them are very consequential, but I will try my best to highlight and explain all of them that are of any importance. Regulation 2 amends a number of definitions in the principal regulation. And, Madam Speaker, the first one is the deletion of the definition for approved agent. And there was a fair amount of debate about that at the last meeting, Madam Speaker, but let me explain the rationale why the Central Planning Authority has recommended that this definition be deleted. As it is presently worded, the provision for approved agent places an onerous burden on the CPA, Madam Speaker, because when we read through, the CPA is expected to act as a regulatory body for enforcing aspects of the trade and business licensing law. Because after all of the other requirements in the definition, the definition as it stands says, and approved by the CPA, meaning after all is said and done, the CPA then is still expected to be able to approve either an individual or an entity as someone or some entity who are allowed to make a planning application. And Madam Speaker, I said before, and I say it again, and as we speak, we are working on it. It is our intention to regulate the industry by presenting to the House as early as we possibly can get the legislation drafted, amendments to the Builders Bill, which was never enacted, and also a new professional registration bill, which will see the licensing of contractors, architects, engineers, and surveyors who are practicing in the Cayman Islands. Madam Speaker, we also are simplifying the definition of dwelling unit by adding at the end of the words housekeeping unit and deleting the words with exclusive cooking, eating, living, sleeping, and sanitary facilities. Madam Speaker, right now, the definition of dwelling unit specifies that there must be exclusive cooking, eating, living, sleeping, and sanitary facilities in the structure. And while a dwelling unit will inherently include the specified items, Madam Speaker, but by including them in the definition, there have been conflicts which have been created with other regulatory statutes. So, as a result, there are instances, for example, in the case of apartments, where a certificate of occupancy cannot be issued presently without the specified appliance in place, when in fact, such items are usually the choice of the purchaser. So it's kind of a chicken and egg scenario whereby developers who build apartments have everything else finished and all of the inspections are done, but until the apartment is sold and the individual or family or whoever buys the unit decides on what they want for appliances, it makes no sense for the developer to go ahead and buy appliances, have to put them in, and lots of times those who sell them won't take them back. So it causes a real problem. So as a result, the building code adequately accommodates for the provision of appliances, giving the planning department the confidence that a CO can be issued, while some of these items are not actually placed in the structure. Madam Speaker, there's also an amendment to the definition of Hotel Tourism Zone 2 to include the area designated as such on the plan, which is set out in Schedule 4. Madam Speaker, the map in this schedule simply updates the existing map to reflect all of the parcels within the area that are zoned hotel tourism. But I want to go a little bit further, because the other changes to the Hotel Tourism Zone 2 are also addressed in the regulations, Madam Speaker. Madam Speaker, we're changing the definition of lot to include strata lots by replacing the definition with lot means a legally registered parcel of land that includes a land strata lot. See, what happens is that the regulations give the word lot to have the meaning ascribed to the word parcel in the registered land law. And the registered land law 2004 revision defines the word parcel as meaning an area of land separately delineated on the registry map and given a number. So we have these varying definitions which give rise to a scenario where strata lots are not shown on the registry map and therefore are not lots for the purposes of the development and planning regulations. So they are not subject to minimum lot size requirements. And this has resulted in numerous strata lot subdivisions with lots that are significantly undersized, but the CPA has no control over the issue since the strata lots, are not lots as per the regulations. So we are clarifying that issue so that these lots can have uniform minimum sizes. There's also the question of a definition of a building permit, Madam Speaker. And in defining a building permit, we are inserting after parking area the words permit means the permit issued under the Building Code Regulations 2013 revision. Madam Speaker, this is simply a modernization of the regs to reflect what is now defined in the Building Code. Under this definition, the department will be able to use a number of building permits for various stages of construction and various circumstances during the construction process. For example, a foundation permit or a green card can be issued if only a foundation will be built at that time, or a fit-out permit if interior work is to be regulated, and so forth. So this gives the latitude to have not just one building permit, but a varying number of building permits specifically designated to what that permit is allowing to be done. Madam Speaker, we also are making an amendment to the definition of quarry. In November of 2012, the definition of quarry was added to the regulations. And over the past year, Madam Speaker, it has become fairly obvious that the definition required a minor amendment in order to bring clarity to the types of activities that would be considered quarrying. So the existing definition is being replaced with quarry means a place where rock, ore, stone, peat, or similar materials are excavated for off-site use to supply material for construction, industrial, manufacturing, or other purposes. And quarrying includes blasting, primary processing such as washing, screening, crushing, or storage of the material excavated, and the making of concrete or asphalt from the material excavated. Madam Speaker, just to use a fairly simple example to explain without this change what actually could have been allowed to happen. If there is a development taking place and there is excavation being done and aggregate is being created, the developer does not have a license to quarry. And normally speaking, once you excavate on a site, and whatever you excavate, whatever aggregate you excavate is used on the same site for whatever purposes, whether it's for grading or whether it's for land reclamation or whatever, then you don't need an actual quarry license because it's not being taken off-site. But with the definition put in 2012, what could actually have happened is someone could have erected, if it's a fairly large development, for instance, someone could have erected a concrete batching plant on the site, used whatever aggregate was reclaimed from that site, and put to the stage that could be used to make concrete. And actually, that person or that entity could create that on site and move it off the site and sell it, which was not the intention. This defines quarrying, and it puts squarely a line in between what is quarrying and what is not. And Madam Speaker, these amendments simply seek to ensure that the definition remains current. Regulation 3 amends Regulation 6 of the principal regs by saying in subsection A, in subregulation 1, replace the words prescribed forms with forms provided by the Director of Planning. Currently, Regulation 6 states that applications for planning permission must be made on the prescribed forms, but there is no schedule in the regulations that depict what these prescribed forms are and what specific forms are to be used. So the regulation is changed to specify that applications must be made on the forms provided by the Department of Planning. And this negates the need for a schedule to be included in the regulations, and it allows the forms to be modified, deleted, or added to as needed from time to time. Madam Speaker, in sub-regulation 2, we are repealing paragraphs A and B and substituting a new A and B. And this is all to do with the same business of prescribed forms. And the new subsection A reads, "No person shall, without a permit, construct or change a building or structure or carry out in respect of any land, building, or structure any work that requires planning permission, and the holder of a permit shall not, in respect of any land, building, or structure to which the permit relates, carry out any work other than the work authorized by that permit." And B will read, "Prior to commencing the construction of or the change to a building or structure, a person shall obtain a permit, and for the purpose of obtaining that permit, shall lodge with the director an application for a permit, which shall be accompanied by the fees, if any, set out in Schedule 2. We're also repealing sub-regulation 3, and the new subsection 3 will read, "An application for planning permission with any setback adjacent to the sea shall include a mean high water mark survey physically defined on the ground, no more than 6 months prior to the application being submitted, and the survey plan shall be authenticated by and registered with the Department of Lands and Survey." Madam Speaker, first of all, it should be noted that this sub-regulation 3 previously applied to approved agent, but by deleting this definition and a renumbering exercise, this now applies to the high watermark surveys. And having said that, this regulation, Madam Speaker, incorporates a policy of the department whereby high watermark surveys must be submitted with applications for coastal development. And Section 8, subsection 10 of the regulations stipulates that the required minimum setbacks, or rather it stipulates the required minimum setbacks from the high water mark depending on the zoning. However, nothing in the regs currently requires an applicant to demonstrate where the high water mark is located so that the required setbacks can be measured. The department's policy attempted to regulate this, but it was found to be difficult and cumbersome to implement, hence the inclusion in the regulations. Regulation 4 amends Regulation 8 of the principal regs and its sub-regulations to address to address parking requirements for churches. We are repealing sub-regulation 1, Roman numeral 1, and substituting the following paragraph. Churches and other places of worship, including ancillary uses such as church halls, classrooms, and recreation rooms, one space per 150 square feet. What that is doing, Madam Speaker, is making the parking requirements uniform, and I will explain. Presently, the parking requirement for a church is calculated at 1 parking space for every 8 seats. Unfortunately, there is no mechanism available, or there is no specific parking requirement for church halls or ancillary uses within the overall church buildings. You have many church compounds nowadays, Madam Speaker, which have the actual church itself. It has the church hall. It might have some congregation area or some after-school area or whatever. And because of how the regs read now, the parking requirements of 1 space per 8 seats is the only requirement for the entire church property, and it's almost impossible to properly calculate it. So the same requirement, by making it one per every 150 square feet, will be uniform across the board when the calculations are made. And if truth be known, and we look at many of these institutional premises, Madam Speaker, many of them have too little parking spaces. And this is not to infringe or to do anything else, but actually to engage in proper planning. Madam Speaker, we are also with a need to address building heights in the hotel tourism zones 1 and 2. And we are repealing sub-regulation 2E and substituting the following paragraph. In a hotel tourism zone, shall not exceed 65 feet or 5 stories, whichever is the less. But when the building is a hotel or apartment in hotel tourism zone 1 or in hotel tourism zone 2, the maximum permitted height is 130 feet or 10 stories, whichever is less. Currently, each zone has a different maximum allowable building height. This regulation facilitates the same maximum allowable height of a development in both of the zones. Madam Speaker, we are repealing sub-regulation 3 because there was an inconsistency and carryover in the regs from the changes to accommodate 10-story buildings. Thus, it has been deleted. D and F, sub-regulation 10D of Regulation 8 in the principal regulation addresses setbacks for canals and inland waterways. As we speak, Madam Speaker, this regulation stipulates that where a shoreline is a canal or inland waterway, there shall be a 20-foot setback from the high water mark. That's how it reads. It reads a 20-foot setback from the high water mark. Through the recent review of an application for a development along a canal, it was realized that a canal does not have a high water mark pursuant to the definition found in the land survey regulations. So, in order to ensure that there is a required setback along a canal, the aforementioned regulation is amended. And as a result, in sub-regulation 10D, the words canal or are deleted, and a new sub-regulation F is added as follows. In areas where the shoreline is a canal, all structures and buildings, including ancillary buildings, walls, and structures, shall be set back a minimum of 20 feet from the physical edge of the canal. So the whole purpose of that is simply to say, instead of a high water mark, wherever the edge of the canal is, the setback is 20 feet. That's all. In certain matters, like what I'm hearing from across the floor, Madam Speaker, the CPA has variance procedures which they can apply when it comes to matters like that. But it's impossible to have every single thing addressed. This is meant for structures, for main structures. So the CPA has variance procedures when it comes to other matters once the application is made and the point is addressed to them. 10E of the sub-regulations defines high watermark setbacks in the hotel tourism zone. Prior to November 2012, Madam Speaker, the required setback from the high water mark in the hotel tourism zone was 130 feet for the first 3 stories and an additional 15-foot setback for each additional story. And in November 2012, the regulations were amended with the intent of stipulating that the additional 15-foot setback would be required for the 4th story and above. Unfortunately, the amendment that was approved stated, and I will quote, with an additional 15-foot setback for the 3rd through the 7th story. And that was a bit ambiguous. So a strict reading of this clause could actually mean that you only require one additional 15-foot setback and not an additional 15-foot setback for each of the stories. So this amendment is only reflecting what was originally intended. Therefore, the sub-regulation is amended by deleting the words for the 3rd through the 7th story and substituting for each of the 4th through the 7th stories to clear the air that for each one there's a further 15-foot setback. 4th through 7 is actually 4. Yes. Madam Speaker, sub-regulation 4G of these regs deals with notices to adjacent landowners by inserting after the words notice of such application the words shall be made on the form provided by the director. And it amends regulation 812A of the principal regulation that simply says that notice of an application for planning permission must be served on adjacent landowners. But it doesn't specify a specific form. So applicants serve notices in varying formats, and it causes confusion, Madam Speaker, in the process. Subsection 7H deals with building height variances. Madam Speaker, what obtains now is that the regulations provide the Central Planning Authority a certain level of discretion when reviewing development applications. And this discretion is often applied through what is commonly referred to as a variance. But Regulation 813, as is written now, is done so in such a manner that the CPA has no discretion to allow variances for building height. And this ties the CPA's hands on this matter, does not allow the flexibility to accommodate situations where terrain characteristics or even creative architectural design warrant minor exceptions to the maximum building height. And at a meeting on the 2nd of October 2013, the Central Planning Authority resolved to recommend to the Ministry that this regulation be amended to allow discretion for building height variances. And so the amendment that is proposed is as follows. In sub-regulation 13, by deleting the words notwithstanding sub-regulation 1 and substituting the words notwithstanding sub-regulations 1, 2. And Madam Speaker, in section 6, the criteria for reviewing certain types of applications for development were originally set out in section 6 of the law, but it is considered an operational matter by both the Central Planning Authority and the Department, And the recommendation is that this is better suited in these regs. And the amendment is as follows. By inserting after subregulation 13, the following subregulation. Where the authority or board receives an application for permission to carry out planned area development or special purpose developments, that is, the planned area development is what is commonly referred to as a PAD. The authority or the board, which is the word board is used for the Development Control Board, as the case may be, may A, consider the likely impact of the proposed development on the infrastructure of the islands, as well as on educational, social, medical, and other aspects of life in the islands. B, consider whether there are other issues of national importance which are relevant to the determination of the application for development and require evaluation. C, consider whether there are technical or scientific aspects of the proposed development which are of so unfamiliar a character as to jeopardize a proper determination of the application for development unless there is a special inquiry for the purpose. For instance, if there is need determined for an environmental impact assessment. D, identify and investigate the considerations relevant to or technical or scientific aspects of the proposed development, which in its opinion are relevant to the question whether the application should be approved. And E, assess the importance to be attached to those considerations or aspects. F, consider whether the development proposed in the application should instead be carried out at an alternative site. And G, arrange for the carrying out of research of any kind appearing to it to be relevant to an application. So those are considerations which the CPA will now have to bear in mind. Regulation 5 of this amendment amends Regulation 9 of the principal regulation to allow for hotel development in a residential zone. What happens now, Madam Speaker, is the development and planning regs allows the CPA to grant planning permission for non-residential uses in a residential zone, provided certain processes are followed. This stems from a recent situation where an applicant was proposing a planned area development, that is a PAD, that included hotel development within the mix of proposed uses. For procedural purposes, the authority considered hotel development to be commercial and applied the procedural requirement of Section 9, subsection 3 of the regs. This procedure was challenged, and after obtaining advice from the Attorney General's chambers, it was determined to be more prudent to differentiate hotel development from commercial development when considering PAD applications. So the amendment that is required will read as follows. In subregulation 3, by deleting the words commercial, agricultural, and substituting the words commercial, hotel, tourism-related, agricultural. So what that will do is specifically identify hotel building within that zone once it is part of a PAD application, that it can be allowed. Subsection 2 amends an inconsistent procedural requirement for notification of adjacent landowners by deleting the words from an owner and substituting the words from an adjacent owner as provided for in Regulation 8, 12A, 12B, and 12C, and lodged within 21 days of the final advertisement. Madam Speaker, the reason for this change is that, again, there's an inconsistency between three existing procedural provisions in the regulations. 812 states that only adjacent landowners within a certain radius may object to an application for planning permission and do so within 21 days of notification. 12E states that only adjacent landowners within a certain radius may object to an application for planning permission within 21 days of notification. But the existing 9.3 states only that an owner can object to an application for planning permission, and there is no time limit for lodging the application. So this inconsistency certainly is obviously an inequitable one. So we believe that all three of these provisions should accord with each other. It is necessary, Madam Speaker, also to repeal sub-regulations 6A, 7A, and 8A of Regulation 9 and sub-regulation 3A of Regulation 15 of the principal regulations in order to delete the density provisions for houses, semi-detached, and duplexes. And I'll explain. Presently, minimum lot sizes and maximum density for houses, semi-detached, and duplexes in all three residential zones, low density, medium density, and high density, and the beach resort residential, contradict each other. For example, in a low density residential zone, the minimum lot size for a house is 10,000 square feet, and the maximum density is 4 houses per acre. But the density of one house on a 10,000 square foot lot equals to a density of 4.35 houses per acre. So one contradicts the other, and if you went by 10,000 square feet, you would get more than 4 houses per acre. Likewise, sub-regulations 6I, 7J, and 8J within the regs address side setbacks in residential zones and speak to the provision for 50% of the height of the building. But they are deleted because that really is, it's not relevant when we speak to the other regulations which have the side setbacks. Regulation 7, Madam Speaker, amends Regulation 24 by repealing sub-regulation 2A and substituting the following paragraph. A, involve a parcel of land or a group of adjacent parcels of land that equals or exceeds 40 acres and may include parcels on both sides of a road. In the existing regulation 24.2, certain criteria must be satisfied for an application to qualify to be considered as a planned area development. These criteria address such issues as parcel size, mixture of uses, infrastructure, etc., as I have spoken to before, Madam Speaker. But sub-regulation 2A states that the application must involve a parcel of land or a group of contiguous parcels of land that equals or exceeds 40 acres. And Madam Speaker, the intent of this single criterion was to ensure that a PAD had sufficient land area that you could do a proper master plan and recognize that not in all situations would one parcel of land be available that would be at least 40 acres in size. The provision allowed for an applicant to group together smaller lots that would come up to at least 40 acres. But you see, Madam Speaker, it used the word contiguous. And in the strictest definition of the word contiguous, that would not allow for a parcel or for parcels to be split by a road. So you could have 5 or 6 adjoining parcels, which would make up 40 acres, but because there's a road going through a portion of it, they would not be considered contiguous. Hence the minor amendment by replacing the word contiguous with the word adjacent, and also stipulating that the parcels can be on both sides of a road. Also, Madam Speaker, we have an amendment to clarify the intent of land for public purposes. The regulation allows the CPA to require applicants for subdivisions to set aside up to 5% of the land for public purposes. And that land for public purposes is to be used for public purposes, including active and passive recreation and public rights of way. However, the regulation is really not clear, Madam Speaker, as to whether the term public refers to the general public or whether that refers to the public within the subdivision from which the LPP was created. We believe that since the LPP remains in private ownership, that it would seem more reasonable to specify that the use of the LPP is intended for the use of the owners within the associated subdivision for which it was set aside. And Madam Speaker, in order to clarify the intent of that regulation, we are making the amendment which will clarify that. Regulation 9 addresses the location of required public rights-of-way in the hotel tourism zone. Regulation 32 requires any applicant to set aside and dedicate to the public a 6-foot right-of-way to the sea, where there is a shoreline frontage of 200 feet or more. In some instances, Madam Speaker, however, there may already be suitable existing public access to the sea in the immediate area, and a new public right-of-way may be better served or better located on an alternative site. The wording of the existing regulation does not state that an alternative site can be allowed, but neither does it state that it cannot. Therefore, to give the Central Planning Authority this flexibility, we are amending this regulation and deleting the words "from the public road to the sea, such," and substituting the words "per every 200 feet from the public road to the sea, either on the subject property or on such other property as may be deemed suitable by the authority." Regulation 10 amends Regulation 34 by deleting the words, "but in the case of an owner-occupier who possesses Caymanian status, no special permission for the occupation or part of an uncompleted building is required if such part complies with the approved plans." Madam Speaker, Regulation 34 provides the requirement for a CO, commonly known as certificates of occupancy, to be obtained prior to a building being occupied. But the regulation also provides the exemption for an owner of a building who has Caymanian status. And it states no permission is required to occupy part of an uncompleted building if that part complies with approved plans. Madam Speaker, what inevitably happens is you get someone with an approval to occupy a portion of the building and they move in for instance. And then as they keep going along, because this exemption allows a Caymanian to do so, there are many, many who simply have no further communication or dealings with the planning department. And the department itself is not able to go through the necessary inspections, and it is a matter of safety for the general public. And there really is no win for it, Madam Speaker, because you want to give your Caymanians an advantage if you possibly can. But with the exemption, there is no way to make them come back to the department for the requisite and necessary inspections. And we just don't see any other way out. That's really what it boils down to, Madam Speaker. We have wrestled and battled with it back and forth and tried to think of everything that we possibly could. Madam Speaker, before I go on any further, I want to speak generally to the amendments to the fee schedules. It has recently come to our attention that there is some confusion in the development industry as to how the particular fees for submitting modifications to approved building permit plans are being administered. The planning application fee schedule currently omits a fee for institutional buildings, and the building permit fee schedule currently omits a fee for both agricultural and institutional buildings. And so what has been happening is, because there is no fee specific to those categories that I just mentioned, the commercial fee rate is being applied as it is the only fee available. So somebody could want to build a greenhouse, and they are charged the fee that a commercial building is charged. That's what happens now. And we are correcting that by specifically categorizing some of these things. We certainly are of the view, Madam Speaker, that applying the commercial fee is not fair in these circumstances. And so we believe there should be a specific fee, and that is a lower fee for agricultural and institutional buildings. In order to address these matters, we have made the changes to the schedules, and I will get to that in a little while. Regulation 11 amends the principal regulation by inserting after Regulation 37 the 37A infrastructure fees. Madam Speaker, this too there was some contention when we made the amendments to the planning law, but this was previously in Section 38 of the Development and Planning Law, and as part of the consolidation effort, and in keeping with the regulations pertaining to the operational aspects, these fees simply have been removed and placed into the regulations. 37A will now read of the regs, 37A1, there is established an infrastructure fund for the purpose of providing funds for development of roads, affordable housing, and other infrastructure in these islands. The fund shall be administered, forgive me, by the Ministry of Finance, and allocations and disbursements approved by Cabinet, and shall consist of monies received under subsection 4. Subsection 3 in this section, A, Area A means the areas designated as such on the plan set out in Schedule 6. Area B means Area B depicted in Schedule 6, and Area C likewise. person to whom planning permission for development is granted pursuant to an application made on or after the date of commencement of Section 26 of the Development and Planning Law shall contribute to the infrastructure fee as follows. And Madam Speaker, let me just finish one more paragraph and then I'll get to all of the fees and explain them all. Regulation 12 amends Part 1 of the Schedule 1, while Regulation 13.2 amends Paragraph 3 of Schedule 2 to address the waiver of fees for a one-time addition to a house not exceeding 10% of the ground floor or 500 square feet. Madam Speaker, this too had some very lively debate when we were amending the planning law, and I gave a commitment to have in the regs the circumstances under which someone could add 10% to an existing building, a one-time 10% to an existing building, which was no more than 10% of the ground floor or a maximum of 500 square feet. So they will now be able to do that addition, Madam Speaker. They will have to make their application and get their tests and get their inspections. But Madam Speaker, there will be no fee. At no stage of the game will there be a fee. Where there will be a fee, which is not a fee but a penalty, is if they do this without going through the various inspection processes. So once they allow proper inspection to be done, they will have to pay nothing. And Madam Speaker, I don't know how else we can do it. So that is how that section of the amendment to the regs will read. Regulation 14 amends Schedule 4 of the principal regulations by inserting after the plan relating to hotel tourism Zone 1 the following plan, which is Zone 2. And now, and the schedule displays that, Madam Speaker. Madam Speaker, the schedules with regards the fees. Madam Speaker, in Area A, what used to obtain, or what obtains until this is approved, is that a house, duplex, or related structure or structures and any extension thereto in Zone A is paying $6.50 infrastructure fee per square foot. A hotel building is only paying $4.50. A commercial building is only paying $4.50. An apartment building is only paying $4.50. So when we look at that, we don't think that that is, I don't know whether it was intent, but we don't think that that's how it should be. So we are reducing that fee to $3.50 per square foot. There is an addition of when there's subdivision of land, there's a $200 fee per lot for under the infrastructure fee, Madam Speaker. And that, Madam Speaker, is simply to assist with street lighting. Madam Speaker, I certainly am not complaining, but I say this because of my own experiences. There is not a day cross when we don't get requests for street lights. And on many occasions, the requests are not for one street light, but it's a brand new subdivision with 30, 40, 50, or 60 homes in it. And it's several roads. And the bill simply keeps mounting. And my view is, in order not for government to be in a situation of having to say, listen, we don't have enough funds to do this. When the subdivision is being created and this infrastructure fee of $200 is collected, it doesn't really affect the price of a lot in the big scheme of things. Nothing to talk about. But this will certainly go a long ways in getting the street light up, even if it doesn't physically take care of the long-term operational expenditure. But we're hoping to get LED lights soon, and hopefully that'll make a whole big difference in the price. Madam Speaker, in Zone B, a house, a duplex, or related structure between 3,000 and 4,000 square feet was $250. From 4,000 to 5,000 was $3, and exceeding $5,000 square feet was $5. An apartment building, a commercial building, a hotel building, an institutional building were all $2.50. And Madam Speaker, we consider that somebody building their own home to live in it certainly shouldn't be paying more per square feet than somebody building an apartment or a hotel, either to sell or to rent. So we are again reducing those fees, 3,000 to 4,000 square feet from $2.50 to $1, 4,000 to 5,000 square feet from $3.50 to $1.50, and exceeding 5,000 square feet from $5 to $3.50. The truth is, Madam Speaker, what used to be also, what people used to be very conscious of is, for instance, if they were looking to do a fairly elaborate home, once they knew where the window was, they would make sure that they would tell their architect, well, make sure the square footage is 1 square foot less than whatever the maximum is. So it really wasn't serving any purpose, and we think we'd much rather be reasonable about the situation and perhaps encourage people to develop. There's also in Schedule the Schedule B, Madam Speaker, for subdivision, it's $100 per lot. And in Area C, which is the largest area on the map in Grand Cayman, Area A is mostly down along the 7 Mile Strip. Area B is kind of South Soundish, if you understand what I'm saying, Madam Speaker. And then all the rest is considered Area C. We're also very conscious about this street light situation and how much the bill is mushrooming up. So there will be a 50 cents per square foot fee for construction in Area C. So we have tried to balance the situation out, Madam Speaker, with those amendments to the schedules. And I think I have covered just about all of the main amendments to the regulations, Madam Speaker. Let me see if there are 1 or 2 more items that I might need to cover. Madam Speaker, where I spoke to about Hotel Tourism Zone 2, the plan or the map indicates the area designated as Hotel Tourism Zone 2 which I've spoken to earlier and which has been approved as a rezone. Madam Speaker, as I said, these changes are meant to improve the efficiency of the department, and they certainly are meant to improve the experience of those working in the industry. And also, Madam Speaker, certainly the aim is to encourage sustainable development for the islands. So I would ask members of this Honorable House, as they look at these amendments, to give their support so that the necessary, if I have determined the necessary legal action can take place, Madam Speaker, so that we can put them into force and have them actually in working order. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. I recognize the honorable member from the District of East End.
Thank you, Madam Speaker. I was waiting for the Leader of the Opposition. It is protocol that I do that. It is protocol that I do that, not about, it wasn't about beauty or anything first now. Absolutely, I know what the protocols are in here. Bring me that thing, please. Madam Speaker, I rise to give a short contribution to this motion before the Legislative Assembly, the Development and Planning Amendment Regulation 2014. Madam Speaker, I believe that it is common knowledge that I had much to say surrounding the Development and Planning Bill that came to this Honorable House sometime in the last meeting. Madam Speaker, at the time an amendment was made to those amendments to reinstate the provision which requires the regulation to come back to this Honorable House for an affirmative resolution. Now, Madam Speaker, I want to thank the Minister for complying with that. However, I think I need to record my disappointment in the government who so eloquently opposed such actions in the past when they were on this side, wherein we came to this Honorable House this morning and the government suspended the standing orders, 25-5 I think it is, to allow this motion to come to the floor for debate, and we have had no knowledge of it coming to the legislature. Now, as a member of the PPM whilst we languish out in the opposition, I too joined the chorus at that time about the way the UDP government was conducting the business of this honorable house. Since I'm still out here, I now make my own objections without any help. Madam Speaker, we know the tenets of democracy and especially how they apply to minorities. We know about the need for fairness, protection of minorities. The Premier, who was then leader of the opposition and member, he and I fought many battles in here concerning it. And here I am having to now fight him concerning it. The more things change, the more they remain the same. That's unfortunate. But be that as it may, Madam Speaker, I have had to go into high gear to try and digest some of these regulations. And I know the minister is going to say we had them. Well, there are quite a few changes since I had them. Madam Speaker, I challenge this government to not practice what they oppose during their tenure in the opposition with this kind of suspending the standing orders to allow these things to come here and not give the members on the other side the opportunity to review them so that we can have meaningful contribution, debate on behalf of the people that we represent.
Member from Eastern, I've given you some lateral to post-discuss the suspension of standing order, but can I ask you now to move on to your debate on the motion which is now before the floor?
Madam Speaker, I guess there's no direction for me to go in that I'm not blockade, but that's the nature of this business. I shall bow to your ruling and move on. It won't stop me today, though. Madam Speaker,
Member from
there are-
Eastern, just out of abundance of clarity, because there are some people who don't quite understand the standing orders as good as you do. There was ample time for you to make those comments when we did the suspension earlier this morning. You didn't, but I still allowed you to expound upon them on this substantive motion. I just asked you now to move on. I'm not barricading you. You already had a right, and I give you an extra right at this juncture.
Madam Speaker, I don't think you're going to barricade me, ma'am. I do respect that I have to move on because, Madam Speaker, let me move on. At least I crossed the line with the chair. Madam Speaker, first of all, I need to find out from the government if this amendment has been assented to and approved. Because, Madam Speaker, this development plan amendment regulation says that it is being done in accordance with Section 42 of the Development and Planning Law 2011 revision. And the 2011 revision 42 was repealed. Madam Speaker, I am merely trying to see if we got this right, because the 2011 Development and Planning Law 2011 revision, as I have it here, and I may have the wrong one, 42.3 says 3 was repealed by Section 12 of 30 of 2010. So I don't know how that is working. I don't know how we're going to be able to do these, because we couldn't amend the revision, could we? That would have to come at the next revision to have that put back in there. So it would have to be the 2014 amendment, as far as I know. So I would invite the government to look at that to see, or maybe the Attorney General can tell us what that means. Madam Speaker, there are a couple of things that I want to discuss on this matter. Let me start by looking at Clause 2E by inserting after the definition of words parking area the following definition: permit means a permit issued under the Building Code Regulation 2013 revision. I don't see anything in the 2000 Building Code Regulation 2013 revision defined as permit. I didn't find it. Usually my eyesight ain't that bad, but I will certainly invite others to look for it. And let me know exactly where permit is defined in the building code. Madam Speaker, I see where the government has included an additional under section regulation 6, subregulation 3, where there's a requirement for an application for planning permission with any setback adjacent to the sea shall include a mean high water mark survey physically defined on ground no more than 6 months prior to the application being submitted. Madam Speaker, whilst I am elated to see this in there, I beg the minister to ensure that it is properly defined what we mean by high water mark. Because we have been down this road as long as I can remember, whether it's the vegetation line or it's where the last black grass came up, or whether they wait until low tide and they go out in the sea and take low tide, which is out long black grass, and then when the tide rise, it only come into where it was prior to the low tide, and they take it there. And certainly, Madam Speaker, I am not prepared to be disrespectful to any surveyor. I wouldn't want to do that. But I can't say that all I'm honest. I don't, or I'm not honest, but I believe, Madam Speaker, what has happened is that they are engaged during those periods, particularly during, people watch these tidal movements, you know, and they know when it come in. And they engage the surveyors at that time. And they submit what they record there. But there needs to be some average method applied, because everybody has stretched our little island to the point that they enlarging it so they can get more area to tell you you can't walk across that section of the beach. That's why they do it. I wonder if they heard about Jack. But that is precisely why people do it. Everybody comes with their neon signs and call us paradise. And you see I'm going to church Sunday morning too. Praying and preaching for low tide. Madam Speaker, I think the ministers and the government's challenge is to properly define that as to what, where, how, when that can be done. I understand within the last 6 months, but they may very well capture a good low tide within the last 6 months. They'll deliberately wait for it and then apply within the last 6 months. Make those things within the boundaries within the last 6 months and apply. And Madam Speaker, I'm sure the minister will remember when he and I sat on planning, and at the time it was the vegetation line. But then somewhere along the line we changed that. So, no. Madam Speaker, I want to turn now to regulation, the amendment clause 4, which amends regulation 8. Madam Speaker, I believe I spoke to the young man, Director of Planning, some time ago about this, and I didn't come away from him with a clear understanding, which is somewhat unusual because he usually has more patience than Joe with the member from Northside and I. But I didn't come away with any excitement from it, and I did forget to call him back. Because, Madam Speaker, as I calculated, a building in tourism zone 8, clause 4, 8, which is sub-regulation 10E, I think. Yeah, in a hotel tourism zone shall not exceed 65 feet of 5 stories, whichever is less, except that when the building is a hotel or apartment in a hotel tourism zone 1, the maximum permitted height is 130 feet or 10 stories, whichever is the less. Madam Speaker, I believe I picked up the wrong one there. It is the one. Here is 7. Madam Speaker, what my point is that I think it's in the area where we talk about this 4-story being used as a setback, and we're changing it now to 4 for each of the 4th through the 7th floors, as opposed of each for the 3rd through the 7th story. But that says 10E, Madam Speaker. Oh, I had it wrong, Madam Speaker. I had it wrong. I had the other side. 10E, in a hotel tourism zone, all structures and buildings up to 3 stories, including ancillary buildings, walls and structures shall be set back a minimum of 130 feet from the high water mark, with an additional 15-foot setback for the 3rd through the 7th floor, and we're changing that from the 4th through the 7th floor. So 4 floors will attract an additional 15 feet per floor. So 130 plus 90 would be the base of that hotel. Is that, Madam Speaker, therein lies my lack of understanding of it. I don't know if it is, the base will be at 130, and then you set back the other, that's up to the 3rd floor, and then 3rd story, and then you keep setting back, stagger it, because that does not cut it. And I know I was confused with that. I know I was confused, because this can mean that in the literal sense, that if you're going to build 7 floors, up to 3 floors, you only need to go 130 feet, period. So if I'm going to build a house in a hotel tourism zone, I need to be 130 feet back. But if a hotel is going to be built, from the 4th, 5th, 6th, 7th, they need to be set back 15 feet each up top. That just doesn't make sense. That just doesn't make sense, because whatever damage the building was going to do, the foot is already there. We're confused about this one, I believe. 100, you had it. This is, I'm looking at the 2013 revision. No. I was confused with it too. You got to look at the regulations. So, you got to look at the 2013 regulations to understand that part of it. So, Madam Speaker, how I'm interpreting this is that you can't go straight up unless you have 190 feet from the setback. You can't go with a straight building straight up 7 floors unless you're 190 feet setback. 130 plus 60, 190 feet. Now that is not going to cut it on on areas, and we got to talk about redeveloping them along West Bay Road in a little bit too, because of the enhanced value that we as a people are not getting value from when we pay taxes on it. So, because whatever damage we're trying, I don't know what we're trying to avoid by staggering them on the top. If it's 130 feet from the sea, we might as well go straight up at 130 feet and give them the, what's called, density. Yeah, but yeah. You can't define aesthetics in law. Madam Speaker, I know we love to define aesthetics by the pictures in our brain. That's how we do it. What is aesthetically pleasing by the wishes of individuals. You can't do that. So, if we're trying to create an aesthetically pleasing building, then we need to make them design it to be aesthetically pleasing. We're not going to legislate laws to stagger these buildings back and back and back. Will soon look like the Taj Mahal. And basically that's what it is when you're going to stagger these buildings back. Let's go up one floor, one straight building. I see the young man from planning. He listening, Madam Speaker. I don't know what the minister will do about it, but no, Madam Speaker. The other one that I have some concerns with is in that same clause 4F, by inserting after sub-regulation 10E the following sub-paragraph. EA. In areas where the shoreline is a canal, all structures and buildings, including ancillary buildings, walls and structures, shall be set back a minimum of 20 feet from the physical edge of the canal. Now I can see us getting ourselves in problems with that. People have boat docks to do. They have changing rooms to do. They got the pools to do. They want gazebo. They put out their, hang over their dock, and then they want the gazebo and their little building for their cleaning of their fish and the what have you. I don't know where the authority would have the authority to give variance in that instance. I don't know where it's in the law that I see the authority giving variances, but I don't think they're authorized to do so. The minister, the current minister responsible for this, and I had many lickouts in planning when we had some kids inheriting their parents' house that was 10 feet from the boundary, and they then wanted to go to the second floor, and we couldn't give them the variance to encroach on that boundary. And then we made them set it back in 5 feet, which ran them into astronomical construction costs. And he and I had many fights with that. So and we were advised that, but we have changed attorney generals now too, since then. So that one advised we couldn't do any variance. We had to go with the law. But I want the minister to explain to us, if he would, how we're going to allow people to do that in there. Now, Madam Speaker, I want to talk and briefly on these, the one I talked about, the 7-story and setting back, because And then we made an amendment to the law to allow 10 stories on West Bay Beach. Now we're making another amendment to do it up at Beach Bay. Now, on West Bay Beach, we all know it has been crowded for the last 30 years. But what we are seeing is the redevelopment of these properties. So you get a development of 30 owners, and they participate in the redevelopment with the developer. And they get, now because there's 10 floors, the density has gone up. They get 60 apartments out of it. Now that current previous owner of the building has an increased value on their properties, and we are not getting anything from it. It is not being assessed as increased value on that property, because if they were buying it outright, it would have been $3 million. Whereas their existing or prior would have been valued at $1 million. But they get a new building, new apartment, and it's $3 million now, valued $3 million, and they just move into it. And the only person paying stamp duties just happens to be those who buy the new ones. We need to try and capture some of that money. Somehow, somewhere. Well, you say that's a horny one? You break the horns off. Somehow, we need to get part of that. Everybody speculates on us and takes us over the coal. And I'm sure, the Minister of Finance or the Minister of Commerce, no? Financial Services. He the one got it. I'm sure he will come up with some innovative ways of changing that Lansing survey. Everybody got to do something in this one. Yeah, we need additional fees off that. That's simple. Madam Speaker, I believe that we need to seriously look into that. And we don't have to is to necessarily do it at what is the usual rates are, because people have invested here for 30 years at least, have lived here for 30 years. But if you have an enhanced value, you need to pay on your enhanced value, some percentage of it. Madam Speaker, I notice where the government, under this Clause 5, is changing, repealing sub-regulation 6A, which is the maximum density. This is in residential now, which changes regulation, amends regulation 9, which is in a residential zone, the primary use of residential and horticulture applicants for permission to effect any development in residential zones shall ensure that the mass and scale, proportion, and design of such development is consistent with the historic architecture tradition of the island. And then it goes on, and in high-density areas, detached and semi-detached homes, and if in suitable locations, guest houses and apartments are permissible, provided A, the maximum density is 8 detached or semi-detached homes, or 4 two-bedroom or 6 one-bedroom duplex per acre. And I heard the minister do some explanation on it. But, Madam Speaker, I wonder what they're going to be now. It's going to be left up to the authority? Because I don't see anything put back in to replace it. It's being repealed. And then I understand the 50% height of the building a little further on, because that just don't make sense. But then in low density, we're taking out the 2-bedroom duplexes per acre as well, which is 8 then. 8A. We're taking that out too. The maximum density is 4 detached or semi-detached houses or 2 3-bedroom duplexes per acre. I don't see it being replaced. And if my eyesight has failed me, then I guess I would invite my people to do that. Now, Madam Speaker, let me move on to Clause 6. I am skeptical. Clause 6, which amends Regulation 15 by repealing subsection 3. No, Clause 7, Madam Speaker. Sorry, do apologize. Which the principal regulations are amended in Regulation 24 by repealing sub-regulation 2A and substituting the following paragraph, which is a PAD, plan area development. And I hear the minister saying that it has to, under the old regulation, it has to be contiguous. Yeah? And he's trying to allow them to cross the road. Madam Speaker, the problem we have with that is, and I guess you couldn't get away from it if the persons own both sides, the problem you have is aerial intervention. Yeah, but a long time. And none of the big people land in Cayman, nobody bought on both sides. You don't worry about that, Bobo. You don't worry about that. They bought both sides for on speculation. You don't worry about that, Bobo. Yeah, one of them roads been about there a long time. Well, I can think of at least 2 places I hear that are trying to do pads now that this would be trying to facilitate. I mean, the one north side, that's supposed to be on both sides of the road. And I understand that they're doing both sides of the road West Bay, so it could apply to that as well. Which 2-side road up there? He not going that east side? That wee piece of land up there? Oh, I don't know. I am just saying I have my own concerns about that. Madam Speaker, in Clause 8, I see where we're amending Regulation 28, and we're including a definition of public in relation to a subdivision, meaning landowners within the subdivision. Now,
Member from Easton, we've reached our hour of interruption, so I would now recognize the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption. Madam Speaker, I can indicate to members we'd like to finish off by 7.
The question is that Standing Order 10-2 be suspended to allow the House to continue its business beyond the hour of 4:30 p.m. with anticipated conclusion time no later than 7 p.m. All those in favor, please say aye.
Aye.
Those against, no.
No.
I believe the ayes have it. Standing Order 10-2 is hereby suspended. Member from Easton, you may now continue your debate.
Madam Speaker, I believe I was on Section 28.6, Regulation 28.6. Now, Madam Speaker, I trust that this government has thought about this because we have had our own problems in subdivisions where the authority mandated that certain areas be left for public use, such as boat ramps. And I can think of at least 2 in subdivisions, yeah, and it was a condition of their approval that it would be open to the public to launch their boats for fishing and the likes. And that is, and later on it became a source of contention between the general public and the change of landowners. And so I need to see what kind of explanation because, you know, we talked about selling out public open space too and combine them over the years. So, Madam Speaker, I want the government to let everybody, let us inform us on what that process is and who will be allowed in there. And I understand if you enhance that subdivision open space for that subdivision, but there are many in this country that was given permission subject to the public use in some of those public open spaces. LPP or POS? LPP was given, land for public purposes, permission was given at the time of those approvals for boat ramps to be put in them. That's the 5%. And they have run the public off it. So tell us if you're trying to get rid of those. I'll try to be nice with on it, no one want to take me on. And I don't want to be calling names up and say, I'm sick of that now. I'm being very nice. Take it as I give it. Madam Speaker, I want to look at 9. The principal regulation amended in Regulation 32 by deleting the word for the public, from the public road to the sea, and substituting the words per every 200 feet from the public road to the sea, either on the subject property or in it, or on such other property as may be deemed suitable by the authority and such. Now, Madam Speaker, I trust that the Attorney General will be listening to this one. Clause 9. Oh, what is 32 now? I trust that the Attorney General, I noticed he was looking quite keenly at the minister when he was introducing it. I would expect the same attention now. Madam Speaker, 32 says, currently, in its current form, says, in hotel tourism zones, the authority, when granting planning permission in relation to land which has a shoreline of 200 feet or more in a development other than private single dwelling units, shall require the owner to set aside and dedicate to the public a right-of-way of not less than 6 feet in width from the public road to the sea. Such right-of-way may be within the area set aside for setbacks under these regulations. Now, Madam Speaker, the minister knows, as a minister, myself, I had more problems with this. This Attorney General knows too, unless his memory slips him. But I have been to him for legal opinion on those prescriptive rights over those same right-of-ways. I went so far, Madam Speaker, as to register the majority of them along West Bay Road, along with the ladies from West Bay, Miss Alice May Co., and some others. I believe what name is that? Okay.
Esma Smith.
And as Miss Esma Smith was part of that committee. I know Mr. Carson was too. Now, those are already prescribed. A lot of them on undeveloped properties that is over 200 feet wide. What is the intent of this? Because, Madam Speaker, if we are going to do what the previous government allowed the DART to do, then I can't support this, which is, under that agreement, combine all of them and put them one piece of property down the road. Yeah, something like that. I don't know. Down Holmont Turner or something like that. That is not the objective of access to the beach. Are we going to get everybody down there and say no Caymanian should walk through or no one should walk through their place? There are prescriptive rights, and you cannot get away from that. Now, the Attorney General may want to stand up and tell me that I don't know anything what I mean by prescriptive rights. But, Madam Speaker, I want to know how we are going to get past that. In this day and age, when every time you ask the government to do something, they tell you, oh, we can't do that because human rights. How are we going to take away the rights of individuals, that prescriptive right that they have down there? You can't give. You can give, but you cannot take away. Therein lies my concern. And the Attorney General, I'm sure, will explain that. But I can think of, it just doesn't make sense. What would you have to do down there? It could only be, Madam Speaker, a landowner who has land in a different location. Maybe we got to put them up there now. Are you unsure, what? That way we can make our people walk to the beach? How are we going to do that? The instances of one proprietor, one landowner owning, let's say, 600 feet of beach, and you get 3 6s, 18 feet out of that by law. How many of those are left along West Bay Beach that you will get 600 feet out of it? That might happen, that's about all. There are very few pieces of property left. And then where are we going to put those, our people who has for years walked across these properties to go to the beach? Are we going to take the people who supposed to go public beach? We can't increase the property there by the governor house because there are condos on one side, the governor house on the, when I gotta make them buy that our governor house? That's the only thing I can do. Yeah, it's about time. So, Madam Speaker, my concern is, how is this going to work? Yeah, you get someone down there with 300 feet, you get 600 out of, you get a 6 foot right away. What are we going to do? Get that proprietor to go down the road to buy a 6 foot right away? Or are they going to buy 100 feet of beach down the road? It has to be similar. It cannot be any less than what we are entitled to. So I just don't understand why we're doing this. It has to be of similar value or better. No, I need to know before I can put my signature on this. And you know, Madam Speaker, in this day and age, them judicial reviews come up quite often about that now. Mightn't win, but we go to them. This is about prescriptive rights in many instances. Madam Speaker, I ain't trying to be an objectionist, but here you know. That old Mose, you know, Minister for Tourism. Madam Speaker, I want to turn to this. Clause 11, this infrastructure fund. Now, Madam Speaker, I want to go over to clause 11, 4. A person to whom planning permission for development is granted pursuant to an application made on or after the date of commencement of Section 26 of the Development and Planning Amendment Law 2014 shall contribute to the infrastructure fund as follows. With your permission, can I read the Amendment Bill 2014, Section 26?
Please proceed.
Madam Speaker, thank you. Section 26 in the Development Plan Amendment Bill 2014 was amended by Clause 17 of that amending bill. And it says the principal law is amended in Section 26 by deleting the word storm bells where they appear in the marginal note and in the section, and substituting the words mangrove buffer. What I mean? Madam Speaker, Section 26 in the substantive law says storm belts are defined as storm belts as indicated on a development plan shall not be the subject of the development or clearance of any or clearance other than by person authorized in that behalf by the authority and to the extent and in the manner, if any, directed by them. I suspect that's a mistake because could never be only the people that do storm, the buffer got pay infrastructure fees. Something not right there. You're right with that. You're right with that, Minister. Something not right there. It says section 26. I see your young man over there looking with glazed eyes. Section 26 of the Development Plan Amendment Law 2014. Madam Speaker, while they look for that, I'll just move on. Madam Speaker, I cannot support the government in its under 37.4 again, when the minister in his introduction said that the $200 for the subdivision of land under infrastructure fee is infrastructure fund fee is for lights. I cannot support that, Madam Speaker, because the time should be nigh that we protect our people. And whoever is doing a subdivision needs to put these lights in. Even if in time government takes them over. But we can't afford this no more. I was going to do a land transfer for a young couple. The young lady from East End, the young man from Borden Town. They married, they got a child. So I said, meet me at the LA. She come. Both of them come. I said, but I can't sign this because the man was, Madam Speaker, I couldn't sign it because it was in an entity name and then on the paper they had the individual name. I said, I can't do that. Anyway, call for the person. I go speak to the person. The lady I couldn't understand the lady or she couldn't understand me, but there was a bad language barrier. So she said, I understood. She sent her husband. And she got to tell him where I am. When he called the couple, he was near Borden Town looking for the LA building. Somewhere by Linford Pearson Highway. Anyway, he eventually got here. I found out that I was talking to his wife, and then I couldn't understand him. But he had come in. The moral of the story is, he had come in here on speculation, bought property, subdivided it, and not going to street lighting it and selling it off. No concern for the safety of your purchasers. And then government got to pick up the tab. Yeah. Why are we putting the onus on us again? Just like planning required them to put in water, roads, electricity. Part of that electricity, shine on. Maybe later, maybe we say After 5 years, when the subdivision is full out, government will take them on. Then we have a responsibility to watch out for the interests of our people. The minister's right. I just asked him for one, must be last week. I'm constantly asking for streetlights. All of us, Madam Speaker. But when these subdivisions were built, the other thing that needs to happen, that needed to happen a long time ago, with the roads. We allow them to do only one application of chip and spray, and 2 years later, you need shine flashlights to see which pothole you're in. How deep it is. But it's not expensive. It is not expensive to do 2 applications. If you're building 100 lots and it's going to cost you $200,000 to put in the road, you got to divide that over the lots, you know. You got to do asphalt. Yeah, because that is now a standard. And why it has become a standard? Because it is the same developers not doing the double application which would last 10, 12 years. Or chip and spray. Madam Speaker, sometimes we have to ensure that government does not pick up these tabs. What do you think we got to spend so much money for? And everybody walks away with it, making their millions off the sale of these properties, and can't spend a measly, I don't know how much those street lights are now, $150? And you only need to put them strategically in there. Maybe 5, maybe 6. You know? What they don't understand is that when you put the lights in and you tell people, oh, we got security, and you're making them pay for it, it attracts people to your subdivision. Instead of single women or women traveling alone who, you know, are fearful of the dark, especially, you know, and then you cater to the women's needs and their security, and they can make their husband come to that subdivision, you know? Of course. But, you know, it's, I don't know, these. Anyway, Madam Speaker, I think the government needs to rethink that and make and require that anyone doing subdivision, they also put in security lighting therein. Because I see one bill coming there now, we're telling them second-hand dealers, they got to put up security light and cameras and all kind of thing. Anyway, Madam Speaker, my other area here is, I don't see anything here for in area B, where there is for anything on the 3,000 square foot house. So no one that can build under 3,000 allowed go in that area? Huh? I see a 3,001 to 4,000 square feet, $1 per square foot, and 4,000 to 5,000, 1/5, exceeding 5,000, 3/5. Under 3,000 free? I don't know what they say. And in the area C, there's 50 cents per square foot of the gross floor of the development and 100 per lot of subdivision. Maybe I'm missing something here, but in Area C, I would think that somebody doing a little 1,900 square foot house would have to pay, what's that, $800? 850? 950? And in Area B, I don't know what it is. There's no application here. I don't see it. Madam Speaker, I go on to 12. Clause 12. Don't tell me it never was because so what are we applying all them charges with? You're not charging what if under 3,000 square feet? Holy God. Okay. All right. It seems rather unfair that me and mine and Mr. Miller's area C got paying, nobody else paying. On the real getting out hand, you know? No, the member need, the minister need help us, you know? No, take off the 5th off area C. No. You go on and the reverse of what I want, Madam Speaker. He's talking about he'll change up to 4,050 cents. No, I am asking him to reverse my section and say nothing up to 4,000 in area C, which is mine and my good friend from Northside's. We've been paying all along and nobody else has been paying. It's time now for us to get a relief.
You mean your constituencies?
Yeah, my constituencies, yeah. We're in Area C. And we have been paying for infrastructure fee forever, and they're not giving us no roads. The B not paying, and you're giving them all the roads out there? Somebody, we need to reverse it at least for a little while, Madam Speaker. Madam Speaker, be that as it may, I am glad to see that the government has changed its position on Clause 12. That is, you know, if you add non-little piece onto your house, because when at first my understanding was that you would have to, anything, any building, whether it's new, 10% or whatever, would attract the same rate. So I'm glad to see. I heard the minister on the radio saying that when the regulations come out, we would see. I'm glad to see that he had a change of heart. And you know, Madam Speaker, one of the things, so that he hasn't had a change of heart, which I asked him, I begged him to do, was to clearly define the removal of shoreline debris following inclement weather. He gone up now $250 with 200, right? Was $250, I believe, Madam Speaker, but he hasn't clearly defined it that it's by mechanical means. And Madam Speaker, I think that needs to be clearly defined, that this is by mechanical means, as I understood it from him during the bill. that it's backhoes and bulldozers and stuff out on, because they want to have greater control over how they move and shift the beach. But I don't want somebody in planning to go to East End and charge the people of East End for raking up their beach. God forbid, we got a policeman in East End, and we all know who he is, that he cleans his beach every day. And Mr. Gilbert McLaughlin. And every bit of Gulf feed that is there, he uses for fertilizer and stuff. God forbid, the enforcement officer goes up there and tells him he can't clean his beach unless he paid $250. So that's just one in my constituency. There are many others, but it doesn't clearly define it. And I know how these things go, Madam Speaker. When you don't clearly define it and leave it, some civil servant is going to put their own interpretation to it. And then we're going to get our problems. So, Madam Speaker, I think I've said enough. I think that the government needs to, I would like the government to answer some of my questions. And they should look into that, really look into that one about the Section 26 of the law. Madam Speaker, I thank you for the opportunity, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, we'll take a short break for 10 minutes.